Hi, this is video 11. We were talking about the Crown submissions in the Sajo Oyang appeal case. That's for hearing starting on the 12th of October 2016, and the Crown referred to the case of the Banco, which was a case in the vacation court, probate, divorce and admiralty jurisdiction, which is a civil court of appeal. It was in England, and the decision was delivered on the 9th of December 1970. So the plaintiff's vessel, the Montague Alita, it collided with the jetty, thereby causing considerable damage not only to the vessel but also to the jetty and the oil installations thereon. And the plaintiffs claim that the collision was caused by the negligent navigation or management of the defendant's vessel, the Banco, and they served a writ of summons and arrest warrant on that ship and 6 sister ships owned by the defendants. The defendants applied to set aside the service of the writ and the warrants of arrest in respect of all the vessels except the Banco, maintaining that on the constructions of Section 3, subsection 4 of the Administration of Justice Act 1956, which is an English act, under the admiralty jurisdiction, that it may only be invoked in rem against the ship or against any other ship beneficially owned by the same person, and that the plaintiffs were not entitled to arrest more than one vessel. And the court in that did hold that the plaintiffs weren't entitled to arrest more than one ship at one time, because of this wording in that section was to be construed strictly as not meaning and or, and the phrase, quotation, any other ship must be construed as meaning ship in the singular and not ships. See, there's a lot of argument in court, isn't there, about little tiny words. In that case, they had a whole hearing over the word and/or and over, quotation marks, any other ship. And so it was held by the court that the Administration of Justice Act 1956 was passed to enact matters agreed at the International Convention relating to the arrest of seagoing ships 1952. The court is entitled to look at the convention for the purposes of resolving ambiguities in the statute, even though the statute does not mention the convention and the statute does not exactly correspond with the convention or the wording of the convention. Notwithstanding that the plaintiff is not entitled to arrest more than one ship belonging to a defendant, a plaintiff is entitled, as soon as the action arises, to issue a writ in rem, only against the offending ship. Notwithstanding that a plaintiff is not entitled to arrest more than one ship belonging to a defendant, a plaintiff is entitled, as soon as the cause of action arises, to issue a writ in rem not only against the offending ship but all the other ships which at the same time are in the defendant's beneficial ownership, because the admiralty jurisdiction in rem cannot be said to have been properly invoked until the writ served. Oh, okay. Which means you can do paperwork to arrest all the ships, but the jurisdiction's not invoked until the writ's been served. So the writ so issued must be amended by striking out the names to arrest once more than one writ has been served. I suppose you could go along to the Admiralty Court and say you want to arrest 7 ships here, and then choose which one you want to arrest when the time comes, presumably the one you can get to, because they get all over the world, ships. Well, that case goes on and on and on, but anyway, that was what that case decided.